Being competent and prepared. We're already 45 minutes in, and Aaron was right. I can actually talk for 2 hours straight, right? Be competent and prepared. Competence equals preparation in a lot of ways. So these two things, even though they're two things, and our rules talk about them as being two separate legal principles, they are one and the same. The rule, Rule 1.1, says competence. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, preparation, reasonably necessary, to go forward with the representation. Benjamin Franklin talks about this in terms of by failing to prepare, you're preparing to fail, right? Go ahead. Okay, and here's the comment. Competent handling of a particular matter includes inquiry into analysis of factual legal elements of the problem, use of methods, procedures meeting the standards of competent practitioners, and it also includes adequate preparation. The required attention to preparation are determined in part by what's at stake. Major litigation, complex transactions ordinarily require more elaborate treatment than matters of lesser consequence. How many of you all have done this? And I have. I'm ashamed to admit it. We all have, I think. Picked up the file and ran to court and tried to prepare while driving on the way to court. Right? That's, I guess you can skate by like that, but that's not doing the right thing every time. That's not being prepared, right? I tried at first, and it's very, very difficult to do it, to apply a 3-to-1 principle. For every hour I spent in court, I was working on that hour for 3 hours. Now, some of y'all might be a lot more efficient than me, but that's what I had to do, and that's why I was at the office all the time, it felt like. Let's move forward. Kind of went out of order again. Let me see. And why do you go the extra mile? Why? Because you never know when the Court of Appeals is going to call you out and call you incompetent. It repeated itself. Let's do it again. Okay. This is a true case, an unpublished opinion from 2001. Nelson versus Commonwealth. The defendant appealed the conviction for robbery. Conspiracy to commit murder, break and entry. Court of Appeals affirmed the conviction, as they always do, right? And then added the following. In a footnote, as a final matter, we note our concern with the performance of appellant's court-appointed counsel. This is in an opinion, right? I know it's not published, but still, it's on the internet for everybody to see. In prosecution of this appeal, Rule 5A20 requires that a party's brief on appeal, quote, shall contain principles of law, the argument, the authorities relating to each question presented. Despite the serious nature of the issues on which this appeal was granted, appellant's court-appointed counsel cited no authority for her claim that the evidence was insufficient to support convictions. The argument section itself comprises less than 1 page of counsel's 3 1/2 page brief and can in no way be said to constitute zealous representation. And then it quotes the rule. Although we did not view the shortcomings in appellant's brief as sufficient to warrant dismissal of appeal, we also do not wish to encourage this representation. Called out for incompetence. Okay, diligence, going the extra mile. Let's talk about the rule for diligence. We talked about preparation, let's talk about diligence. Diligence, Rule 1.3, a lawyer shall act with reasonable diligence and promptness in representing a client. You don't intentionally fail to carry out a contract of employee entered into with the client. You also you shouldn't intentionally prejudice or damage. The big thing you want to focus on here is, or today at least, reasonable diligence and promptness in representing your client. Now, the comment 1 to Rule 1.3 says a lawyer should pursue on behalf of the client despite opposition, obstruction, of personal inconvenience, and may take whatever lawful and ethical measures are required to vindicate the client's cause or endeavor. Now, this doesn't necessarily mean make up facts or do it. It doesn't mean that. It means you do the hard work, the real work ahead of time to make sure you do it. And then you also have to be cognizant of your limited capabilities as a human being. A lawyer's workload should be controlled so that each matter can be handled adequately. I know in private practice how difficult it is to try to juggle multiple counties and multiple courts and multiple types of cases on any given day. If you're attorney of the day in General District Court, you've got 10, 15 cases going, some of them serious, some of them not serious. All of them should be handled, and maybe that same day you might actually have to go to another county and practice as well. Diligent work, you know, the part of the rule and part of the ethics is that you have to make sure that you schedule yourself accordingly and don't take on too much. And I'm preaching to the choir because I have a hard time saying no. Anybody here else have that problem? I will join any event, any club, and go and speak at anything, and then realize later, oh God, I don't have enough time to do 12 different things at once. It gets me in trouble every once in a while. Not necessarily in work, but at home for sure. Let's move forward. And then the biggest thing, and our rules specifically talk about procrastination. Do tomorrow, I don't know. Let's move forward. Rule 1.3, comment 3, says perhaps no professional shortcoming is more widely resented than procrastination. A client's interest often can be adversely affected by the passage of time or the change of conditions. In extreme instances, as when a lawyer overlooks a statute of limitations, the client's legal position may even be destroyed. Even when the client's interests are not affected in substance, however, unreasonable delay can cause the client needless anxiety and undetermined confidence in the lawyer's trustworthiness. Did I say that right? Y'all were looking at yeah. All right, so procrastination. It's a big deal, and it should be avoided, right? Now, let's talk about, and y'all already know about this stuff. You live it. But let's talk about some real examples of where attorneys, either because they were too involved or they didn't pay attention to detail, they got themselves in trouble. Now, this is one example that's not a lawyer. You know, a teen who skipped jury duty had to apologize to the judge. That was in the Houston Chronicle in 2010. A 19-year-old college freshman was hauled into a Texas courtroom, and he was arrested at ankle and wrist restraints by the U.S. Marshals because he didn't appear for jury duty. Now that might be extreme, but the law has extremes, and this is one extreme that we're talking about. Why so serious? Well, it's because we expect equal justice under the law, we expect the rule of law, we expect that no person is above the law. And also, law, like other restrictions placed on us by society and by our parents and others, defines the acceptable behavior in society and what's unacceptable. And law is more than just a list of forbidden stuff as well. For instance, law bestows benefits, as we heard about earlier. It creates new programs. It reflects our morals and values. It creates certain activities, predictability. It establishes our government. It also relates to economics. Now, then the biggest three are these. Law helps us fulfill the three biggest emotional human needs, and that is, don't get mad, get even. Justice is finally done, and it's the principle of the matter, right? Whose legal fees go up if the client comes in and says, I don't care, it's just the principle of the matter, right? Amen. Move forward. Okay. So, don't know why I keep repeating this one. It wants us to make sure we get this. Okay, and then of course, we settle things like adults through litigation, right? Now, I'm not an expert on federal civil procedure, but I give this lecture at the beginning, when I teach at UVA-Wise, at the beginning of my class, the very first day of class, I give this set of slides. Why? Because I want our students to know why I treat deadlines as important. I will not give you credit on a paper if you turn it in late, because I give you all the tools to write the paper the day one. Kinda, it's the same way in our rules. So let's talk about it. Federal Rule of Civil Procedure 1, the very first one in the book. It must be important, right? It says these rules govern the procedure in a civil actions proceeding. And then the next slide underlines that they should be construed and administered to secure, just, speedy, and inexpensive determination of every action and proceeding. It doesn't matter if it's civil or criminal or any other administrative type of law. Our law is set up to do these three things: to secure justice, to make sure it's done quickly and then to make sure that it's done in a way that's not terribly expensive and inaccessible for the public. Now, when we talk about that, that principle governs the next things we're going to talk about. Here's a case. Link versus Wabash Railroad. It's a 1962 case. Petitioner's automobile collided with the railroad train. Petitioner filed a suit in 1954, and then a 6-year delay followed. The district court notified attorneys of a pretrial conference. The petitioner's attorney called the courthouse, which was 160 miles away, it must be kind of like this, and asked the judge, who was actually on the bench, asked for the judge. He was told by the judge's secretary that he was busy preparing papers to file in the Indiana Supreme Court, and that he couldn't be there at 1 o'clock today when the pretrial conference was set, but he'd either be there Thursday, October 13th, or any time thereafter, Friday the 14th, if it could be reset. So you're calling the day of the pretrial conference saying you're working on a brief for the Supreme Court, so important, we need to reset the pretrial conference after a 6-year delay. Now, when the plaintiff's counsel didn't appear, the court, the judge, held that the attorney failed to provide a reasonable reason for his non-appearance, and the court dismissed the case for failure to prosecute the action. The court acted on it at 3 o'clock. He was supposed to be there at 1 o'clock. He was late, 2 hours late. The issue that was on appeal, of course, he couldn't refile it because it was outside of the statute of limitations. So the issue on appeal was, did the trial court abuse the discretion in dismissing it, and when he didn't show up on time, and they noted that the case had been continued for 6 years without action. The analysis that they looked at, is this fair to the guy? Looking at things in Rule 1 context, just, efficient, and inexpensive. The court certainly had discretion to conclude that there was not an adequate excuse, obviously. He's got the power to dismiss it, and obviously the attorney screwed up in double booking himself or putting off the Supreme Court petition until the last minute. And all those things are true, but should it be the client's fault? And the holding was, yeah, it's the client's fault. Holding it against the client is not unjust. Go ahead. The plaintiff voluntarily chose his lawyer. This is the rationale. You chose your lawyer at your own peril, and the principal is bound by the actions of the agent, right? So, of course, the client can actually sue in malpractice, but it's not an abuse of discretion to dismiss this case here. The rule, prejudice, can be suffered by a client if you screw up. Y'all know that, right? I don't have to reiterate it, but I will, because we got 2 hours. Wainwright versus Sykes. A man was convicted in Florida of murder. He asked for a new trial because he claimed that the jury heard inadmissible evidence. Pretty standard, right? Well, his lawyer failed to object to this alleged inadmissible evidence at trial while it was being presented. And then he appealed, asking for a new trial where the evidence wouldn't be admitted. So the question was, can the defendant get a new trial when his lawyer messed up by failing to object? We all know this, the contemporaneous objection rule. And the answer, we know, is no, we can't get a new trial for that. Contemporaneous objection must be made. But why? It's impossible for the client to be involved in every single strategy and object. We don't want them objecting at various times during the trial and controlling the litigation. But he must, the client must accept the responsibilities of his attorney's decisions. Our courts are based on the desire to see justice done and achieved, and we can't just keep relitigating things over and over and over and over. So if you screw up in trial, you're sleeping, you mess up. You're out of luck if your lawyer messes up. Even if it's a criminal matter, even if the evidence is inadmissible, and even if it was a court-appointed lawyer and not a hired lawyer. Right? So the lessons, Link, you mess up, your civil case is thrown out. Wainwright, you mess up, potentially an innocent man goes to prison. Now, I don't know if there's anything more scary for you all than that, for me. I mean, I'm the Commonwealth attorney, so we charge folks, I want convictions. But the thing that I want to make sure of the most is that we don't convict people who are innocent. And I want to make sure that I'm very clear about that. So this is a tragedy when someone an attorney screws up and evidence that shouldn't be admitted was admitted because the lawyer wasn't paying attention and didn't object. The rationale, we've talked about it. Let's move quick forward. Again, the client chooses his attorney or is appointed his attorney at his own peril. Appointed attorneys, right? If you can't afford a lawyer, the trial will go a lot faster. Did y'all hear the one about the lawyer? Okay, the trial was going on. Old lady on the witness stand. And just to make small talk, good morning, ma'am. The prosecutor's talking with her. Good morning, ma'am. How are you? I'm good. Do you know who I am? Yes, I do. You're Mr. Such and Such. And then she begins to editorialize. And you're a no good, sneaky sleaze bucket who lies in court. And the prosecutor says, oh God, okay. No more questions, and sits down. And then this defense attorney gets up and says, all right, I think I can do better. So he says, ma'am, good morning. Do you know who I am? She says, yeah, you're that guy that's cheated on his wife and stole from his clients and do this, that, and the other. And the judge said, whoa. If any of you ask if she knows who I am, I'm going to put you in jail. Okay, let's move forward. Federal Rule 6. Now, a little bit different, but when an act must be done within a specified period of time, it can be extended for good cause, right, in certain circumstances. All right, so that's the lesson here. You can ask for an extension if you have to in some cases, unless it's outside the jurisdiction of the court. Let's move forward. So let's talk about Carlisle. Carlisle is a case, another criminal case. It's a Supreme Court case in which this guy was tried by a jury for conspiracy to possess with intent to distribute marijuana. In 1993, July 13th, the jury came back with a guilty verdict and was discharged. Now, July 23rd, Carlisle filed a motion for judgment of acquittal pursuant to Rule 29C. Then, that rule provides that the motions must be filed within 7 days, right? Which doesn't include Saturdays and other things. He was 1 day late. 1 day late in filing his motion for judgment of acquittal. So weird procedural history happens now. So the trial court denied the motion for acquittal August 19th. And then when Carlisle appeared for sentencing in October, the judge did something inexplicable. The judge actually reversed and said that there was insufficient evidence to convict him. Actually took up the motion for judgment of acquittal at sentencing in October. Well, of course, the government appealed and said you can't do that. It was outside the 7-day window. And it went all the way to the Supreme Court. Now, let's look at things. The issue the Supreme Court had to determine was this. Does the trial court have the jurisdiction to grant a post-verdict motion for judgment of acquittal filed 1 day outside of the window? And the analysis was that the drafters of the federal rules said that 8 days was too much to file this motion. And even if the trial court has power to extend deadlines, there are certain deadlines that are jurisdictional. And this is one of them. So, if you allow an exception here, it's going to create a cascade of exceptions that engulf the rule. I don't know who wrote the opinion. I'd have to look that up, but I'd be interested to see who wrote that opinion. Some rules establishing deadlines, like Rule 29C, are jurisdictional, specifically listed, and therefore can't be extended, so Rule 6 doesn't apply. Of course, this is a criminal case. But anyway, 1 day here is not good enough. So what's amazing is that this judge actually believed that the guy is innocent. In October, found that he was innocent. But because the lawyer didn't file the motion on time, the judge couldn't do that. Isn't that crazy? I don't know. I mean, it's crazy to me. But, wow. The trial court has no power. Even if he thinks it's innocent, to grant the motion because he didn't file his paperwork on time. And a lot of these motions that we're talking about can actually be done orally. They don't have to be written motions either. I mean, for instance, this, anybody who practices federal criminal law? Suzanne, help me out here. Can you file a motion for JNOV or judgment of acquittal orally? You can. Wow. Okay, let's go forward. Here's a Hopper case. United States versus Hopper, Second Circuit, 1940. Criminal case, Hopper convicted of narcotics and firearms offenses. August 21st was his conviction, or his sentencing date. Judgment of conviction entered by the court the 27th. Deadline to file the appeal, September 8th. Notice of appeal filed September 10th. September 16th, the attorney filed a motion to allow a late filing of the notice of appeal. Y'all get the pattern here, right? In November, the court denied that motion. The attorney instructed his legal assistant to prepare a notice of appeal and file it immediately. The attorney did the right thing. Right after, he said, go ahead and file that immediately. Well, she didn't immediately file it. She thought that it would be more efficient to file it at the same time as filing other things, his application to be appellate counsel. And she believed that the deadline was 30 days, not 10 days. So, on appeal, he argued, it's not fair. I tried. It was my assistant that goofed. I did everything right. I'm the lawyer. My assistant goofed. My assistant didn't know the law. She's not a lawyer. And this is the legal term, excusable neglect. Well, the analysis was that he didn't mean to. There's no indication of bad faith. And the reason for the delay was simply an oversight. And the attorney or his staff, they lacked familiarity with those federal procedures. But that's not an acceptable excuse. How many times do we hear in court, especially criminal defendants who say, I didn't know the law, I didn't know it was illegal. Well, I know I've defended guys like that. Well, even lawyers who don't know the law, knowledge of the law is not an excuse. So the result here was his appeal was denied. There was a late filing. Even though the extreme circumstance, it was caused by an honest mistake, carelessness, or whatever, but that carelessness led to his client suffering prejudice. In a criminal case again. Again, maybe, they were convicted as a jury, so we're just talking about an appeal here, but this is a federal appeal, so it's a guaranteed appeal. So maybe an innocent person convicted because, or sentenced and non-appealed because the lawyer screwed up. Again, nothing more tragic than that. Oh gosh, another one. Now this one involves the Social Security benefits, and I added this one just for David Berry. So, Social Security case. McCarty was hit by a car in May. She suffered physical and mental health problems, diagnosed with PTSD. McCarty applied for Social Security, and they denied the application. McCarty's application for benefits were denied. Appeals counsel denied, and then she went to the District Court of Indiana. And I'm not exactly familiar with the procedures here, but I do know this. 63 days later, because the court made it very clear, 63 days later, McCarty filed a notice of appeal. June 5th, McCarty filed a motion for with the court requesting a 3-day extension to file a notice of appeal. So you have time to file a motion to extend it, but you don't have time to file the notice of appeal. It just doesn't make any sense. But anyway, in a memo, the client states that McCarty's attorney misunderstood paragraph 11 of administrative policies. So the attorney messed up. He took additional 3 days. And the appeal ensued. And the argument was, I'm disabled, and the evidence shows I'm disabled. And the government says, you abused your discretion by filing it too late. And the analysis, again, was we got procedures here that require it to be done within 60 days. And a district court can extend that only upon a showing of excusable neglect. So unaccountable lapse in basic legal knowledge here was held not to be excusable neglect. And so the jurisdiction was lacking here. Again, it's just like the other case for the civil case. So it doesn't matter if it's civil or criminal. So after all those cases, I'd like to begin by making the same point about 20 times in a row. Pay attention to deadlines and details. Now, We all know, I've already talked about the contemporaneous objection rule. There's a reason our Supreme Court and Court of Appeals both say if you don't object in very, very rare circumstances, you're not going to get to appeal on those basis. And it's wanted to do it like 12 times. The Court of Appeals even said just even endorsing an order seen and objected to is not enough of an objection as well. This was a 1991 case. Now the point of all that, they're watching, right? Did y'all hear that? You remember the Geico commercials? Who's watching this little stack of money with eyes? Googly eyes. Well, the point is that your failure to plan, it may cost you, the failure to actually take time to do your planning work and scheduling work might cost you. It might cost your attorney, but it certainly, it might cost your client. Ultimately, everything you do, they're watching. And that's why there's probably so many bad lawyer jokes, right? Everybody has known something that has gone wrong, and that, of course, the lawyer gets blamed for it, and they give a bad name to our profession. The point is you have the ability to be diligent and do what the rules say, and that is be prepared. And if you can't handle all the stuff you've got going on, maybe you need to downsize your life. A few years ago when I became Commissioner of Accounts, I was practicing in Lee County, and Dickens County, and Wise County, and Scott County, and sometimes traveling over to Russell, and doing 3 different courts in almost every county, and trying my best to juggle all that, and kids, and a wife, and running the business, and trying to be involved in politics and everything else. I realized very quickly I couldn't do it all, and maybe you've gotten to that point, maybe you haven't, maybe you can handle it all like Superman, but your work is never done. The rules require diligence, the rules require promptness, and representing your client. There's more comments. I put them in the materials. Let's move forward to another big topic that goes along with this same thing, and that is effective time management. Effective time management and goal setting is probably one of the most important things you can do as a lawyer. Ethically, one of the most important things. I say almost even more important than communicating with your client. It's managing your time so that you know your expectations can be met. The expectations of the client can be met. So how do you do that? Stephen Covey's 7 Habits of Highly Effective People says, I think there's one that pops in, planning, scheduling, prioritizing, and reviewing your work. You've got to plan. You've got to schedule that plan. You need to prioritize it in terms of what's the most important, and then review what you've got periodically. I keep this notebook or a notebook similar with me everywhere I go. It's got a to-do list on it, and sometimes I rank them in what has to be done first. I do this every single day. I have what they call CDO. You know, it's kind of like OCD, but in alphabetical order the way it should be. So how you do that is you, I know it got so bad during law school, and actually I still do this a little bit. I even set out my suits for the week on Sunday. I know that's extreme, but it works. So I set them out on Sunday so that I know I don't have to go in, God, what am I going to wear, or whatever it is. It's done. It's prepared. It's ready to roll. I schedule meals and everything that way too. My wife also is a control freak with schedules, so that's part. I used to be a scheduler. That was my job. I managed the schedule for the Attorney General. So of course I'm going to ultra schedule my own. Back. Stephen Covey's book, though, says you should take your to-do list or your time and divide it up into 4 quadrants. We have the urgent and not urgent category, and then important and not important. We've got crises. These are things that are urgent and important. And then we've got things that are trivial, busy work, phone calls, emails, that are not urgent and not important. How many of y'all actually schedule time to at your office to answer emails and mail and stuff. I have to. I get so many, I don't have time to do them. And if I don't schedule and make a time to do it, I'll do it on my phone and I'll miss something and something will be out of whack. I actually am behind in my email, so if you've emailed me recently, there's a reason. It's not in my priority zone. It's not urgent. Some of them might be important, so they might jump up here. That requires your planning, provision, and preparation. Organizing your life, of course, this is the reason why you do it. When you're organized, you have this special power. You can, I know this is great. This is great literature right here. You walk into the room with a sure sense of purpose. Your priorities are clear in your mind. You can orchestrate complex events like practicing in 5 different counties at the same time. With masterful touch, things fall into place when you reveal your plans and you move smoothly from one project to the next with no wasted time or emotion. Throughout the day, you gain stamina and momentum as your successes build. How many of you I love it. It makes me feel like I am doing something when I mark off my to-do list stuff that I planned to do that day, right? You gain momentum. You people believe your promises because you always do what you say you're going to. When you enter a meeting, you're prepared with whatever it may be, and when at last you show your hand, you're the winner. Okay, that may be extreme, but here's how you get to it. You have to set your priorities, place priorities on your calendar, allow a little bit of time for unexpected stuff, do your projects on time as best you can, organize your workspace. If your desk is a wreck, you can't find what you need at the moment you need it. Work according to your temperament. So if you're an early morning person like I am, I get up at 5 or 4 and I start work. That works for me. I can't work late at night. I get too tired. Use your driving time for your personal growth. I listen to audiobooks or listen to the news or sometimes music, and that helps. And then you have to develop the system that works for you. How many of y'all have a computer calendar or a calendar on your phone? How many of you go the old-fashioned paper route, right? Paper calendar. Some works for some works for others. So you never know what's going to be the right fit. Always have a plan for the meetings, for the minutes between meetings. When I used to go down to the jail and meet with clients, I always would bring something to do because I hate wasting time. I don't know why. It's just the way I was born. I hate that time of just sitting there with nothing to do. And it takes focus and energy to plan for those moments. And then we've already talked about this. People get paralyzed if you have too many priorities. I know that happens to me. It happens to us all. If you got too much to do, how many of y'all have gone to your desk, sat down, and I don't know where to start. And then you spend 30 minutes looking at your emails because you don't want to have to start or worry about where you start, right? Well, that's because our brain can only focus on certain things enough at a time. And so you need to try to figure out a way to limit the number of your things in your life. Again, I'm preaching to the choir, to myself. And it's unethical not to do it. The rules say it's unethical not to do this.